When dealing with a private law application, and in particular a child arrangements order application, the court will make a number of assumptions. This is still the position even when one party makes an allegation of domestic abuse. What are these assumptions? First, the court must make a decision that is in the best interest of that particular child. The second is the court has a duty to promote contact with the parents in accordance with the child's rights to family life under Article 8 of the European Convention of Human Rights. The third assumption is there is no presumption either way as to whether or not a child should have contact with a domestically abusive parent. The fourth is that the involvement of both parents in the life of the child will further the child's welfare. But these presumptions are just the starting point and will not apply if the evidence shows that any involvement by the parent will expose the child to a risk of harm.
Where do you draw the line in practice? Because the list that you initially draw up will have people who are looking after the child during the time frame when the injury might have occurred. And if you can't identify one of the people on that list as the perpetrator, there's a good chance that everyone else will find themselves in the pool. And so the process by which you try and exclude them from the pool is either to take an active role in relation to stage one, which is the identification of the perpetrator, or run a case that there's insufficient evidence to keep them in the pool. And that's really the only two ways of doing it. But what you have to be careful about doing when you're running that second element of the case, i.e., can they be excluded from the pool, is to keep on emphasizing to the judge that you only get to that if the court hasn't identified a perpetrator. You don't start with that process, X is out of the pool. You might argue X is no longer on the list after oral evidence, but make sure you distinguish at all times during your argument or the presentation of the case and witness statements between the list, which is mere opportunity, and the pool, which is mere opportunity plus no perpetrator having been identified, plus more than mere opportunity, something that takes it beyond mere timing.